Hello and welcome to another view from Mayor Brown. This sits alongside our regular podcast and is an occasional series of interviews with those involved in the changes going on in employment law. The podcast is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to another view from Mayor Brown. This is our special guest podcast series. As you know, we have a practice of inviting people onto the podcast as guests to the series where they have perhaps a different view on things, they come from a different background. And today I'm delighted to be joined by Tanem Taskin, who is an Australian qualified lawyer, admitted in 2011. She worked most recently at Norton Rose Fulbright in Sydney, but we'll try not to hold that against her, and we certainly won't mention Norton Rose again in this podcast. But she's the newest associate in the employment team here, and she's going to talk about, or provide some insight really for UK employers who might be either having gone into Australia to employ people or thinking of doing so. The sort of differences that might strike UK employers as surprising, or just the way things are done, or some of the pitfalls that you might fall into if you simply take the same approach to your Australian employees that you take with, say, your English employees. So, Tanem, delighted to have you on board.
Thank you, Nick. Thanks for having me.
So, let's start with quite a general question. How would you describe the way workplace relations in Australia are organised?
Sure. Australia has quite a layered workplace relations system. If you imagine a pyramid, it's probably the easiest way to explain the kind of different layers. At the base of the pyramid, for example, would be the primary legislation regulating the employment relationship, the Fair Work Act. Within the Fair Work Act, there are then the National Employment Standards, which are commonly referred to as the NES. And the NES are like the 10 Commandments of employment law in Australia. They're essentially the statutory entitlements that cover the minimum conditions, and they address things such as maximum weekly hours of work, leave, public holidays, notice of termination, redundancy pay, and the right to work flexible arrangements. There are then the kind of state employment laws that also deal with certain aspects of the employment relationship, and usually those are not found within the Fair Work Act. So those sorts of things are, for example, long service leave entitlements, which differ in each state or territory, making things a little bit difficult on that front. And equally, there are state-based statutes which deal with discrimination and work health and safety. The next level on top of that would probably be the industrial instruments. So when I say industrial instruments, I mean the modern awards and the enterprise agreements. And then on top of that, you would have the usual sorts of things such as the employment contract and any company policies and procedures which govern the employment. There are obviously things in between, but that's essentially the kind of framework that you see in Australia's workplace relations system.
So it sounds like you've got quite a number of levels within that, and whereas in the UK you've got, as a generalisation, you have statutory arrangements and the individual contract, and there may be a collective bargaining agreement in some cases. You've got a much more layered level in general terms for employees in Australia.
That's correct, yes. And they essentially provide for safety nets, if I could put it that way, and each sort of layer sits on top of the other, providing increased minimum entitlements depending on the instrument.
Okay. Now, I want to ask you one specific question. You mentioned modern awards and enterprise awards. Now, that's not terminology we have in the UK. So do you want to just tell us a little bit more about modern awards and enterprise awards and what they are and how they're different from each other?
Of course. I appreciate it's quite a foreign concept in the UK. So when I talk about industrial instruments, as I said, we talk about modern awards and enterprise agreements. And both of those documents include minimum terms and conditions of employment, and they supplement the NES, so the 10 Commandments, although, as you've pointed out, they're quite different to one another. So I'll start by talking about modern awards. These were introduced as part of the new federal workplace relations system. They're generally industry or occupation based, and they're set by what is referred to as the Fair Work Commission, so essentially the government tribunal. They contain minimum terms and conditions for most employees. That being said, there are certain occupations or executive and managerial employment categories that are award free, and that can be a critical point which we can come to later on. I think there's something to the extent of 122 modern awards, and they range, as I said, they cover rather a range of industries and occupations, and they address aspects of the employment relationship. For example, they set minimum wages, look at the types of employment, whether it be full-time, part-time or casual, and what the definition of those will be in that particular industry. Arrangements of when work is performed. They set overtime and penalty rates, the option of having annualised salaries, allowances, and then the procedures for consultation and dispute resolution. On the other side of the coin, there are then what we call enterprise agreements, or EAs as they're often referred to. And these are enterprise-specific agreements that are negotiated between a company and its employees, although usually the union will become involved and act for an employee or represent them in the bargaining process. So the Fair Work Act governs all aspects of the negotiation, the approval and the operation of EAs, and importantly, in order for them to be approved, they need to pass what we call a better off overall test. And this simply ensures that employees are not disadvantaged, but are instead better off overall than if the modern award provisions had applied to their employment instead. And a key feature of this, which is usually something that can often cause perhaps some tension or some complications, or even sort of drive up the bargaining process, is where a union official is acting as the bargaining representative for employees during the process. So that's generally quite a unique feature.
So let me just ask a couple of questions on that. I'm going to ask about awards and award-free, the concept of award-free in a second. But in my terms then, are the modern awards like a sector might have a modern award that supplements the terms, whereas enterprise agreements are, if you take the insurance sector might have a modern award, and an insurance company within the insurance sector might have an enterprise agreement that provides similar levels of protection but makes some variations to the sector agreement. Generally, is that the sort of concept we're talking about here?
Generally it is. So as you've said, a modern award is kind of those minimum entitlements. So, for example, if taking your example of the insurance sector, they would have, although you've picked a tricky one, because generally...
change the example. If it makes it easier, change the example.
We'll say the construction industry. So
right.
The construction industry or manufacturing industry, for example, manufacturing industry is governed by the Manufacturing Industry Award. So the modern award contains minimum terms and conditions, which we went through, things like overtime, penalty rates, how the work is to be performed. And then if you were to say, for example, as a company, think, well, there's certain aspects of the modern award that are quite rigid, or we want them to be a bit more flexible, or actually we pay our employees much more than the minimum wage, but we tend to give them overtime at a later point in the day. Those are the sorts of aspects to achieve the flexibility that you would normally see that individual companies would then look at negotiating an enterprise agreement.
Okay. Now, the other thing I wanted to ask about, you talked about award-free, that certain employment categories were award-free. I appreciate this will vary from award to award, but in general terms, what sort of employment categories are award-free?
Absolutely. So the coverage of a modern award, or the application of a modern award to an employee's employment, is usually quite a critical one and can often be a rather difficult exercise. But the sorts of categories that are usually accepted to be award-free are, for example, HR professionals, lawyers, particularly once they've passed the sort of graduate sort of stage, professions such as accountants and those sorts of aspects. So there are modern awards that might touch on some of those categories, but generally speaking, they are accepted to be award-free.
Just following that for a second, are senior executives also award-free? I mean, is this? Do these agreements tend to be focused on protecting the lower paid, more vulnerable, or is that not, as a generalisation, is that not right? No,
as a generalisation, I think that's absolutely right. As you say, that there are always exceptions to that. Usually, the more senior an employee, the less likely they are to fit in within the kind of awards classifications. So if we were to take, for example, the Clerks Award, so there's an award that's called the Clerks Private Sector Award, and it basically starts at clerical employees that are, for example, receptionists, and then it goes all the way up to what you'd probably see to be an executive assistant or an office manager. So that's the sort of range that you would see. Okay. Anything above that, we would say is award-free.
Was out of scope of the award.
Correct.
Okay. All right. Next question then. I'm sure you've seen a number of occasions UK employers taking advice in Oz, and there's a look that people get where you're giving them advice, thinking, you can't be serious, that can't be the way it's really, that's not the way we do it. And of course we all know in our heart of hearts, just because it's done one way in one country, it's not done the same way in another country. What are the three things, let me limit you to three things that differ between English and Australian employment law that you've seen surprise employers?
I'm assuming you mean employment law rather than the weather that's different. But I think...
Not commenting on us, Abraham.
Well, first and foremost, I think the most surprising aspect, and certainly in my experience, having been in the UK for a short period, is probably the leave entitlements. And in fact, all forms of leave are quite different between the two jurisdictions. So looking at a few examples, in Australia, employees are entitled to 20 days of annual leave. That entitlement accrues each year and carries over to the next, and then it's paid out on termination.
So can I just interrupt you?
Of course.
So you don't have the concept there that if it's not used, it's lost?
No, we don't.
Right.
It will accrue progressively, and that's often something that can cause a sort of a difficulty for employees in terms of managing the kind of leave liabilities that they have accrued, because obviously you can appreciate with an employee with a sort of a long service, say of anything above 5 years, those liabilities can start to become quite significant.
Yes. Okay. All right. So you got this accruing holiday leave, and I can see that could quite build up. What else about? You mentioned a number of points, and I jumped in on the first one.
No, that's okay.
Because I'm already surprised.
No, that's okay. Exactly. You'd probably be surprised to hear that you can also cash out in certain circumstances annual leave. So that there are, annual leave in itself, there are some. I guess it's been an area of change somewhat as the industries are sort of changing and work is becoming more flexible. We have seen some areas of the legislation adapt to that and be updated. But another aspect is the long service leave entitlement. So in Australia, employees are entitled to additional leave after a particular period of service with their employer. So all aspects of long service leave are governed by the relevant state or territory-based legislation, and they generally vary across each of those. But a common entitlement is that an employee with 10 years service will be entitled to 2 months leave.
So that's a one-off period of 2 months, but obviously it could be taken in bits.
Well, yes, and it keeps accruing. So I won't sort of get into the... it's actually quite a complex area of the legislation, or quite a complex area of the Australian workplace relations system.
It would be very niche for us to have an entire podcast on Australian holiday rules.
It would be, I would say so. And usually you see some very complicated tables that set out the differences between each of the state-based and the sort of territory statutes. But in a simple sort of summary, each 10 years is the sort of first hurdle, although there are, again, states that will have a kind of a pro rata entitlement. But then an employee, once they've hit that certain number, whatever it might be, depending on the state, it will continue to accrue. So an employee, for example, that's had 20 years of service would have 4 months of long service leave entitlement. And like annual leave, it accrues, it carries on to the next year, and it is paid out on termination. So again, something that employers should be mindful of in terms of managing the leave, and also ensuring that those liabilities are minimised to the extent that they're possible, and obviously they have the legal mechanism to do so.
I was going to say, are employers entitled to tell employees to take leave? Or is that that may be a generalised question that's not a fair question? But I'll ask it anyway. Go on.
In some cases, they can. So I won't get into too much detail because, again, it does depend on whether or not there's a mechanism in the award. It depends on whether or not the employee's award free, and therefore it's governed by the Fair Work Act. But generally speaking, there is some power to do so. But again, it very much depends on the instrument that governs the employment.
Okay, well, let's leave, pun intended, let's leave holiday behind. But what else? We'll talk about three things that surprise. So holiday entitlement and the leave process. I'm surprised.
Secondly, I'd probably say the existence of the industrial instruments. So the kind of foreign concept of modern awards are quite different. There are a number of kind of key safety nets, if I could put it that way, which govern the relationship as we've talked about. And it kind of means essentially that employers don't necessarily have the freedom to enter into any arrangement that they'd like. It's not a case of as long as the employee and the employer agree, then it's fine. But instead, the employer does need to meet a number of minimum terms and conditions. So that's usually something that I would find is quite surprising to the non-Australian employers.
Okay. What about the third thing then?
The third thing I'd say is that Australia, unlike the UK, has no code for disciplinary and grievance procedures to be followed. So whilst it's not a case of you can do whatever you like, it does have does require procedural fairness for employees, particularly those that are covered by the unfair dismissal regime, but it certainly is far less stringent than the UK.
Okay, so some good news there for employers. Let's just talk about unfair dismissal for a bit, because I confess I'm not entirely sure how unfair dismissal works in Australia. So there are unfair dismissal rights for employees?
Yeah, sure. So under the Fair Work Act, an employee can bring a claim for unfair dismissal if they consider that the termination of their employment was harsh, unjust or unreasonable. And in assessing whether a termination fell within that category, the Fair Work Commission will take into account a number of factors. And the primary remedy for unfair dismissal is reinstatement, although compensation can be ordered where that's not appropriate. So you can probably see, for example, where an employee works for, say, a large enterprise with a few thousand employees across the nation, a reinstatement order can be sort of more easily awarded. But where an employee is part of a team of, say, 20 people or a company of 20 people, you can start to sort of see where that might be impractical or perhaps not appropriate. The compensation, there are limitations to this, so it's capped at the lesser of 6 months' pay or half what we refer to as the high income threshold.
Even in cases where reinstatement or re-engagement is ordered, the employer can choose not to comply and just pay extra compensation. And there's a separate. Now again, this is all very, very rarely done. It's in Australia. Do you have the ability to say, hell no, I'll pay an extra fine, or does reinstatement, or is it impossible to generalise because there are variations between states, for example?
So there's no legal ability as such for an employer to, once the order is handed down, particularly to say, well, actually, I'll pay X amount of money and can we turn it into compensation? That being said, it probably is something that can be traversed at an earlier stage. So one of the sort of features of every unfair dismissal claim is that there is a compulsory conciliation process prior to the matter being heard before the Commission. So, I'm just thinking perhaps at that point it might be something that the parties may wish to negotiate and may wish to discuss and reach some sort of landing point. But once an order is made by the Commission, that is the order, and really it must be complied with.
Okay, all right, fine. The other question I wanted to ask about unfair dismissal is who has unfair dismissal rights? Because in England, of course, some employees don't have. You have to have been there for 2 years. But once you've been there for 2 years, continuous service, then generally, if you're an employee, you have unfair dismissal rights. How does it work in Australia?
Sure. So it's not as harsh as a 2-year minimum service requirement, but there is a minimum employment period that employees must have completed before having access. So that minimum employment period for a small business, for example, of 15 or fewer employees is 12 months, and for all other employers is 6 months. From there, the employee must earn either less than the high income threshold, which I believe is something around $142,000, although it's indexed annually, or otherwise be covered by a modern award, which, if you recall, I did mention that the kind of coverage or the application of a modern award to an employee becomes quite critical, and it's in this context where that's probably engaged.
So if you're partly covered by a modern award for something, say leave, but not the full scope of the modern award, then you could end up getting unfair dismissal rights.
So a modern award actually applies to either an entire occupation or the entirety of that industry. So you can't actually pick and choose which aspects of that will apply to you.
You don't have modern awards that partly apply to an employee. If you're covered, you're covered.
You're covered.
Okay.
So taking the example again of the sort of clerical positions, the Clerk's Private Sector Award would govern once you fall within not only the coverage term but also the classification of that award, then you're covered.
Okay.
And so you would have access to the unfair dismissal regime in that instance.
So it's one of the oddities about employment law in England that we have this quite restrictive approach. You have to have been there for 2 years, but once you have it, everyone's covered. The chief executive has unfair dismissal rights. Now, they may not be worth as much because there's a cap on the award, which may drive down the value. But it's this much more egalitarian approach in some ways. Once you're in in comparison with Australia, which I think I've seen in other European countries where high earners are deemed capable of looking after themselves and they don't need the same statutory protections.
In a sense, yes, that sentiment's probably carried through to Australia, yes.
Next question, what practical advice would you give to an employer who's looking to set up in Oz, just bearing in mind the employment pitfalls or things that you might assume, well, this is the way it's done in England, so I'll do the same in Oz. What are the sort of bits that you'd say, remember this and don't forget that?
Sure. Well, I think the sort of obvious one, based on what we've discussed, is that employers should definitely be careful not to recycle UK-based employment contracts. It's probably not a good idea in any sort of jurisdiction, but I think given the unique safety nets which apply in the Australian framework, for example, the NES or the provisions of a modern award, it would certainly be important to ensure that these minimum entitlements are captured in any employment contract. So I think that's definitely something, just as a starting point, might be basic, but something that could prove to be quite important.
Okay, what else?
Probably related to that somewhat is an employer's policy framework. So you probably know more than I do that it's become quite the trend for employers to implement global policies or handbooks, often to achieve consistency or have a standardised approach to its employees. And given the differences between the jurisdictions, I think that employers should certainly proceed with caution on this front, and I guess remain mindful of the application of the local laws.
Yeah, it's often the tension, isn't it, between the desire to have some sort of uniform approach, which is easier to apply, and the gap between, mandatory local laws or best practice or cultural issues or whatever.
Absolutely.
Okay, interesting. Okay, now I've given you warning of this question because I always like to ask a personal question at the far end, and the one I thought I'd ask you about is to pick a favourite film or piece of music, book, and say why. So, films, music, or books?
I think lock in films.
Film. Okay, we'll go with films. So, favourite film and why? Well,
although it was actually tough to pick one, but that's probably because my taste is rather extreme. But I think the one that I've come up with is as at one end of the spectrum, I'd probably say Sister Act, because sometimes all you need to do is switch off and have a little bit of fun. And at the opposite end, I'd probably say my favourite film would be American History X. So a film that conveys quite a powerful message and I guess reminds us of the challenges that people face in life.
Wow, I was going to say that's quite a unique pair of choices. So there you go. Yes, I was going to say I did ask the question. So there we go. So Tanem, listen, thank you very much indeed. That's been really interesting, and I've certainly learned stuff just talking to you in terms of the differences, and I think it's a really, really good introduction to Australian employment law and the sort of challenges it can produce.
Great. I'm glad that you found it helpful, and thank you for having me.
Thank you.
So, that concludes this podcast. We hope that you find it and others in this